Parliament's law has been frustrated.
Thank you. Dr. Eyolfson.
All right. Thank you, Mr. Chair. Thank you all for coming. This legislation, I've always believed is a long time in coming, even long before I was in politics. I practiced emergency medicine for 20 years in Winnipeg. And one of the things I found in my experience was, in one respect, cannabis was a very dangerous drug in that it does kill. And how I found that it kills is through the criminal activities of those who market it. I saw an unconscionable number of gunshot wounds and stab wounds and fatal beatings, and the vast majority of them were due to the drug trade. I was once evacuated from an apartment building that was firebombed over a bad drug deal. Back in the late 80s. Not my apartment, but the building I lived in. So I know the extent of the violence of the current regime and how thriving the black market is. So it's been important that we make a change to this. Now, in regards to some of the concerns that I've heard brought up, now, the provinces may set their own ages. You know, some, we know that the Canadian Medical Association suggested 21. Our legislation says a minimum of 18. Now, there was an experience in the United States a number of years ago. They increased their drinking age to 21 across the board. But before that, there was a variation in ages. They had an experience where if there was a drinking age of 19, on one state, and a neighboring state had 21. You had a lot of people traveling over to drink, and a lot of accidents. They use the term blood borders. Now, if there was too much disparate age restriction between provinces, would you see that kind of a public safety issue?
I think the situation that we have in this country now recognizes that provinces can make those decisions, and that we do actually have different ages for alcohol. I think I would also offer that the provinces are very alive to that issue that you're raising, and are having discussions amongst themselves about the areas where they might wish to achieve consistency. You know, what are those areas where they might wish to have consistency, and where are those areas that they could you know, live with that inconsistency but put in place mitigation measures of some kind.
All right, thank you. Now, in regards to the policing costs, there's been a lot of you know, speculation. Well, you know, the province is saying, how much is this going to cost? You know, we should be getting money for policing. Is there an estimate as to how much the current regime is costing police departments? Because we know police resources are right now being used in, you know, arresting people for simple possession, these people going through the court costs, these sorts of things. And also the societal costs of these people with criminal records that can't get jobs now because of this. So is there an estimate as to how, if not a solid number on that, then how the current costs of our current legal regimen might compare with what they would be after this legislation's passed?
I could perhaps, my colleague from Justice, Madame Morancy, could respond to that question.
I don't have an actual estimate of the cost, but what I can indicate to the committee is what's the magnitude of the charges and the offenses before the criminal justice system today. So you may know that the Canadian Centre for Justice Statistics releases an annual report on police-reported crimes, and in the July Eurostat, which reflects the 2016 data, they reported that there were just over 95,400 offenses reported to police under the Controlled Drugs and Substances Act. Of these, 58% were relating to cannabis. If you drill down further from there, cannabis possession was the #1 charged offense. So in 2016, 76% of the charges were for possession of cannabis, or 17,733 charges. How does that translate to the criminal justice system? Well, the committee may know that the Supreme Court of Canada pronounced on the issue of delays in the criminal justice system in July 2016. volume, the number of cases being processed through has a huge impact on the system. So presumably, as C-45, if and when C-45 is enacted and implemented, one would expect to see less charges being laid for simple possession. To the extent that there are charges or there's an offense being committed, police would have new authority under Bill C-45 to deal with ticketing for smaller amounts that are slightly over the 30-gram possession, so between 30 and 50 as an example. And then beyond that, the regular penalties would apply. So Bill C-45 would definitely have an impact in diverting many charges from the system officially, to the extent that some stay in, provides new tools to police and Crown to deal with them in a more efficient, effective way. Thereby, we would expect reducing some of the costs to the system overall.
Thank you very much. How much time do I have left?
1 minute and 12 seconds,
Great, thank you.
approximately.
All right. Now, this is directed at justice. They talk about some of these offenses being ticketable offenses as opposed to criminal record. Now, one of the concerns that people have regarding anything to do with drugs, we know that people who travel to the United States, if you so much as admit to a border officer that you've ever consumed marijuana, or if you're even on the public record as admitting it, that you might be indefinitely banned from entering the United States. If you have one of these ticketable offenses, like I know that U.S. Border Services would have access to any of your criminal records. Would they have access to these lesser offenses? So if you had one of these tickets, would this be somehow accessible to the database of U.S. Border Services?
I think there's two parts to the question, and I'll start, and then my colleague can finish. In terms of the ticketing offenses, the Bill C-45 requires that if a person is convicted pursuant to a ticket, that record, judicial record of that conviction on the ticket remains separate from other records and cannot be used to identify the person. So it is treated differently than a criminal record. And then to the rest.
And just to build on that, it's currently prohibited to import or export cannabis. That will continue to be the case. It will continue to be prohibited to import or export it under the Controlled Drugs and Substances Act. Moreover, CBSA will be undertaking awareness campaigns. They have received some funding to do that. They'll have clear signage to warn Canadians not to take cannabis across the border, and also Canadians should be aware that cannabis is illegal at the federal level in the United States, and so we'll make that very clear to Canadians and make sure that they understand that that is and continues to be the case.
Thank you.
Ms. Morency, could you clarify that statistic you gave us on 76%? What were those numbers you gave us?
So of the number of charges actually laid for possession of cannabis, there were 23,329 persons charged with cannabis-related offenses. Of those, 76% were charged with possession of cannabis.
Okay.
So we can provide the link for the Juristat to the committee.
If you would, please, yes.
So it came out in July. It's the Juristat for the year 2016 data.